Hi, this is Rick Ryder, President of the Securities Arbitration Commentator, introducing our panelists and moderating another podcast in SAC's series on securities arbitration issues and topics. In this podcast, our focus is on employment disputes between brokers and their employing brokerage firms. The area is too big to cover well in a single podcast, so we'll deal here primarily with two 2018 developments that could have major impacts on how employment disputes are resolved. We'll discuss first the U.S. Supreme Court's May 21 decision in Epic Systems versus Lewis, and as time allows, developments in the resolution of rating disputes, especially the repudiation by several large brokerage houses of the long-standing broker protocol on recruiting. In this fast-paced podcast, experts and practitioners in the securities dispute resolution field we'll discuss the current state of securities industry employment arbitration, including what the Epic Systems decision may mean for the financial services sector. It's my pleasure to introduce briefly our esteemed panel. Full bios will be provided in our flagship newsletter, the Securities Arbitration Commentator, aka SAC. George H. Friedman is principal of George H. Friedman Consulting, LLC, and also serves as chairman of the board of Arbitration Resolution Services, Inc., a completely cloud-based ADR provider. He retired in 2013 as FINRA's executive vice president and director of arbitration, a position he held for 14 years. He previously held a variety of positions of responsibility at the American Arbitration Association for 22 years, most recently as senior vice president. Mr. Friedman is an adjunct professor of law at Fordham Law School, where he has taught a course on alternative dispute resolution since 1996. He is a member of the Securities Experts Roundtable and of SAC's Board of Editors. James L. Comey, a partner in the Chicago office of Howard & Howard, concentrates his practice in civil litigation and counseling matters, with an emphasis on employment and trade secret non-compete issues. Mr. Comey is known for his representation of clients in the financial services industry and has appeared in dozens of FINRA arbitrations throughout the United States. He has published articles on a variety of legal issues relating to financial services and is a contributing legal editor of the Securities Online Litigation Alert, SOLA, a SAC publication. Jeffrey Little is a founder of Little & Robinson, LLP, and handles litigation and arbitrations involving employment law issues of all types, securities litigation and regulatory matters, and complex corporate and commercial litigation. He has tried many securities industry arbitrations to a conclusion at FINRA and previously at the NYSE and NASD and at the JAMS and AAA forums. He has also tried cases in numerous federal and state courts. He has won landmark arbitration awards, including one that made case law at the Sixth Circuit, Glennon versus Dean Witter, several that exceeded $20 million in assessed amounts, and he has also achieved a $168 million separation payment for a senior executive in a public company. Dana N. Pescasolido retired from the active practice of law in 2015 after 36 years representing all elements of the securities industry, firms, registered representatives, and customers. During his 25-year career, which included heading up the securities litigation group at Saul Ewing and 11 years as deputy general counsel at Legg Mason, he handled or supervised well over 1,000 cases of all varieties. In addition, he co-founded what is now known as the Fisher & Phillips Broker Recruitment Seminar. He now serves as a FINRA-approved mediator, limiting his practice to securities-related matters, consistent with his expertise. Dana has made an invaluable niche for himself as an author, writing articles based on research dealing with arbitration results and trends in the areas of customer cases, recruiting/rating cases, and promissory note cases. Welcome to you all, panelists. So, what are some of the broad issues we will be discussing today? In the next 40 minutes, the panel will discuss 5 major topics and several subtopics. We'll start with a brief look at the current securities arbitration landscape. We'll move on to explain the ethics systems decision and what it means for the use of class action waivers in securities employment arbitration clauses. In parallel fashion, we'll look at the Schwab case, where class action waivers were outlawed by FINRA in customer cases. Then the broker protocol. Is it expiring or evolving? And finally, our customary look down the long road, where will we be 3 years from now? So let's turn to our first topic, the current securities employment arbitration landscape. The top growth of disputes right now is expungements. It's also the area in greatest flux, which may recommend it for coverage in a future podcast. Promissory notes are on the ebb this year, but they continue to occupy an important place in disputes between members and brokers. So to get us started, Dana, can you tell us where things stand on expungement and promissory note cases, please?
Sure, Rick. Thanks a lot. First, let me address the issue of expungement, and then I'll move on to promissory notes. I think you talk about the landscape here, and I think with respect to expungement, we're going to be seeing the landscape changing considerably, whereas on promissory note cases, it may be more just a trimming of the shrub, so to speak. I know I'm not going to spend much time on these because I know we want to get to the issue of epic systems and the protocol. The Securities Arbitration Commentator recently did a study on expungement cases showing that brokers win expungement requests about 75% of the time overall. Less often when it's part of the underlying case where they win the case, but where the arbitrators have heard negative things about them. And not surprisingly, they win more often than that, about 80 to 90% of the time, when it's after a settlement or they file a separate case where the customers normally don't show up to tell their side of the story. And that's not inconsistent with statistics FINRA cited when it sought changes to Rules 2080 and 12805, which govern expungement, recently when they submitted rule changes to the SEC. But the really big news is that in 2017, FINRA proposed sweeping changes that I think are going to make it harder and more expensive for brokers to obtain expungement. What you want to be looking at here is Notice to Members 17-42. The comment period is now over. It ended in February. And the SEC has actually issued a letter in April generally supporting these changes, making a few comments on them. But I think most of the people who live in this world fully expect most of the changes that have been suggested they're going to come. Just to give you a little bit of a highlight of what's coming, and we could do an hour on this very easily, but just a real quick highlight. If a customer case proceeds to hearing and the broker is named, he has to request expungement at least 60 days before the first hearing date. If he's not named, or if the case settles, meaning the broker doesn't really get his day in court on expungement, then he's got to file a separate case at additional cost. The panel in that case is going to be sort of a blue ribbon, all-attorney panel, which has to be specially expungement trained by FINRA. So that tells me they're going to be looking at attorneys, people with significant regulatory experience. You're not going to get what you would think of as public members. You're not going to get nurses on your panel. In order to grant expungement, this is a big change. It has to be unanimous. So the panel who hears your expungement request, no longer majority, it's got to be unanimous. And the panel also has to find, in addition to what they already have to find under 12805, that no investor protection or regulatory value exists with regard to the information that would be expunged. Pretty high hurdle. I think it's going to change. In addition, from an expense standpoint, no more telephone hearings. These are going to have to be in person or by video conference. So it's going to be more expensive for brokers to go to the forum, have their attorneys go to the forum. It's going to add a lot. I think that really changes the landscape. So for a while now, brokers have been winning maybe 75% of the time that they push for expungement. I think these changes are coming maybe this year, maybe later this year, and I think these win rates are probably going to be going down. Let me turn now to promissory note cases, because Rick mentioned in his introductory remarks that the number of these cases is ebbing, but it's still pretty significant. If you look at FINRA's statistics page, you'll see that about 300 cases were filed in 2017, still a fair amount of cases. That is down about 40% from 2014. So it went from about 400 to almost 500 cases, rather, down to around under 400 cases. Why is this? I don't know. I mean, I think we can all speculate, is it because stable markets beget stable brokers? They're making good money. They're not as incentivized to leave. Maybe there are more early settlements and cases are avoided so that the filings aren't there. No one really knows for sure why this is. I suspect if we get into another hot market for brokers, these cases will come back up in terms of number. Now, the conventional wisdom on these is always that the firm wins and they're not worth fighting. I'll tell you, I've done a lot of research on this. I'm working with Rick now on an article that may get published in the relatively near future. I've done statistical analyses from 2015 through 2017. And I got to tell you, this conventional wisdom that the firm always wins, it's not entirely true. When registered reps are represented by counsel and they fight the case all the way through hearing on the merits, firms didn't always win everything. They only won 100% of their principal about 2/3 of the time. So 1/3 of the time, the firm got less than 100% of the principal back, and they may have wound up owing the broker some money. They only won attorney's fees about half the time, even though the promissory notes all say the firm is entitled to attorney's fees. And they only won pre-award interest under the note about 60% of the time, even though the promissory notes all provide for pre-award interest, often at higher default rates under the note. So it's only about half the time that they win these extras, and they only win 100% of the principal about 2/3 of the time. Brokers who file counterclaims got satisfaction about 25% of the time. About 3 out of 4 cases, the broker's counterclaims were simply thrown out, but 25% of the time they got something, and in about 1 out of 5 cases, they completely washed out the firm's claim, and in some cases, won net awards. Okay. Now, there's no reason to think this is going to change anytime soon. I know we're going to discuss Rule 13806 soon, but I don't really think that's going to change the results. It's more procedural than substantive. Yet, as a mediator, I'm seeing a disconnect between what both sides see as winning cases versus what the real-life statistics show. These inflated statistics that get thrown around, like firms win everything 90% plus of the time, that includes brokers who don't even post, and brokers who represent themselves, and they get hammered. It seems in these cases that both sides are more intransigent in their positions than what I see in customer cases. It seems like in negotiating these cases, the best defense brokers seem to offer is I can't pay, and then they work out a deal. But like I said, I'm currently working on an article with SAC. Now, hopefully the statistics that we can put into this article will serve as a guide, hopefully to help parties better appreciate the realities of these cases and how they get decided once they go to hearing. And I know I'm statistics. There's lies, there's damn lies, and then there's statistics. We've all heard that. But if you take statistics with a grain of salt, they can be helpful in guiding our thinking and getting folks to better assess the value of their cases. So that's it, Rick, on expungement and on promissory note cases. Back to you.
Well, thanks, Dana. Those are some interesting statistics. I look forward to your article. Jim, can we spend a few minutes just talking about panel composition in promissory note cases, a la FINRA Rule 13806?
Sure, Rick. As our listeners may know, promissory note cases have their own special code provision at FINRA, Rule 13806, which was adopted in 2009. And the idea behind the adoption of a special rule for prom note cases, I think, was a good one to try to simplify, streamline these cases. As Dana noted, these cases, prom note cases, do comprise a significant part of FINRA's docket. And so I think the goal of adopting a special prom note rule was a good one. The difference between the prom note rule and processing under the regular rules principally has to do with the number of arbitrators you get. Then also there's a provision for having a case heard on the papers if the broker files an appearance but does not answer or file a counterclaim. Now, the thing is that in my experience, that almost never happens, meaning the broker almost never simply files an appearance, and the cases thus really aren't being heard on the papers only. Thus, the efficiencies that were, I think, the target of the changes in Rule 13806 really haven't been achieved. We are still facing protracted proceedings in these cases. Brokers almost always file defenses or counterclaims. and thus the cases go on for a year or two, including on cases that I think if the firm was in court, if this was being heard in court, the firm would be able to get rid of the defenses or counterclaims by motion. But that's not possible in FINRA, as everyone knows.
Mm-hmm.
And so at this point, I think it's really FINRA should realize or face up to the fact that the prom note rule really isn't achieving what it was intended to achieve, and should consider making some additional modifications. Maybe something like the new simplified arbitration rule, which was recently promulgated, providing for telephone hearing with limitations on the length of presentation by each side. Each side gets 2 hours for its case in chief, half an hour for rebuttal, and limitations on the examination of witnesses, puts more of the burden for questioning on the arbitrator. Maybe something like that. The details of a fix are beyond the scope of this discussion today, but I do think it's something that FINRA really should consider, because as Dana pointed out, even though prom notes are down, they still are a very significant part of the FINRA docket, 300 cases in 2017, and so I think it would be helpful for FINRA to take another look.
Yeah, that's a good suggestion, Jim. We'll have to see how those new improvements work in the simplified cases. Jeff, could you walk us through the current rules framework governing employment cases?
Sure. So employment cases can arise in many different contexts and are considered to arise in many different contexts. And there are several rules in several areas within the overall set of rules that set forth different panel composition issues and different procedures that might be utilized. So we're all familiar, I'm sure, with the sort of the normal employment case where an employee, whether a broker or investment banker, brings a case against a member firm, and in that case, we have the requirement that the 3 arbitrators be 2 public and 1 non-public, and that arbitrator chairman must be a public. Okay, so there could also be a promissory note case that started either by the associated person or by the firm. If it started by the firm and there's no counterclaim, it's going to be a 1 arbitrator case, and there's a defined number of qualified arbitrators for those cases. If it's started by the firm and the associated person brings a counterclaim on some other issue, failure to pay a bonus, wrongful termination, or some other issue, the arbitration panel will be as it is in the normal course of what I described earlier as a regular dispute. These cases are very much the standard and, shall we say, the most common cases that are brought. We are also focused recently on the statutory discrimination cases, because those cases require that both sides agree and do not agree to bring those cases in advance of the dispute arising. So both sides are required to be willing to sign a submission agreement, and this usually requires that there some level of negotiation in advance as to whether or not the statutory discrimination case is best in arbitration, or at a different arbitration forum, or in court. And several of the member firms have provisions requiring that statutory discrimination cases be held at the AAA or some other forum. so you can have those different rules go into effect. But if statutory discrimination case is going to be held at FINRA, the arbitrator's qualifications are laid out in some detail in Rule 13802, which requires that the chairperson, or if it's a single arbitrator of a 3-arbitrator panel involving this, have a number of qualifications, including a law degree, membership in the bar, substantial familiarity with employment law, and 10 or more years of legal experience, of which 5 must be in either a law practice, law teaching, government enforcement of equal employment opportunity statutes, experience as a judge, an arbitrator or mediator, or experience as an equal employment officer in an, or in-house counsel of a corporation. So these qualifications trim down the list quite a bit, and they are applied either to the single arbitrator or to the chairman of the 3-arbitrator panel. Now, you start to have a little bit of a divergence as to how you're going to, who's going to be on your panel, and how this is going to be organized when you start to have rating cases. So you could have a rating case that's a member-member case, and the selection of that panel is governed by 13402A. And you can have a rating case that's a member actually suing, more along the lines of a non-compete, suing the associated person instead, and that's governed by 13402B. The difference is where the claim is all members, they're all non-public arbitrators, and where the case is associated, a member versus an associated person, you go back to the 2 public, and one of them is a chairman and 1 non-public arbitrator.
This seems a little strange, doesn't it, Jeff? That I mean, rating disputes are quintessential member or industry kinds of disputes. Funny that they allow the public members into those.
Yeah, no, well, they're quintessential industry disputes, but I think you have to take a look at the section of the 13402, because it does provide, and it could provide, there could be a case that's essentially a rating case against a former employee to try to proscribe the former employee's conduct without just going after the new employer to seek an injunction.
Well,
so when that occurs, under then the 13402B comes into effect, and you go back to the other type of selection process.
Right.
Other than that, the rules have become very, very detailed over the years on a number of scores, and they include the 2 major sections on statutory discrimination cases, 13802 and 803. They include an extensive and detailed set of procedures with regard to seeking either temporary injunctive orders or permanent injunctive relief when you go to court, when you can't go to court. And of course, there are rules with regard to these expungement cases and with regard to the promissory note cases that were discussed a little bit earlier. I think the one thing that I would just add is that many of the expungement cases, at least that we handle, don't arise out of a customer case. They arise out of some sort of a yes answer to one of the item 7 questions on the U5. And in those cases, the procedures that will be followed will be very similar to any of the normal, regular employment law cases, with a standard of expungement that'll be date back to that 1996 standard that simply, without any of the excess baggage, that there must be a finding from a panel that that the U5 was defamatory in nature.
That gets at what I wanted to ask. Thanks, Jeff. George, let's move on to the Epic Systems matter and what it might mean for the employment arbitration cases in the securities field. To start us off, I'd like you, as our resident professor of law, to briefly describe the case and the core holdings.
Okay, yes, thanks, Rick. I can be brief. Basically what happened in 2017, the court granted cert in 3 cases that all were quite similar. The core issue was the National Labor Relations Act, which has a section saying employers can't interfere with concerted activities of employees. And what that meant as regards to the Federal Arbitration Act, specifically if an employer uses a class action waiver, is that interfering with concerted activities of employees? National Labor Relations Board sure thought so, and there were several decisions where they said you can't do that. Employers cannot use class action waivers in an arbitration clause. The circuits were split on this, and the court took up the issue. And the core issue again was, who wins? Which wins? Which statute wins? Federal Arbitration Act or the National Labor Relations Act? Well, what did they hold? In May, there was a 5-4 decision authored by Justice Gorsuch. As an aside, what's interesting about that, he didn't ask a single question at oral argument. So although I was fairly certain he'd come down on the pro-arbitration side, I wasn't positive because he didn't ask a question. But nevertheless, he authored the majority opinion. There are 3 prongs to it, very simply. The first part says, look, under Section 2 of the Federal Arbitration Act, the courts must enforce the arbitration agreement according to its terms. Then it moved on to the question of the apparent conflict or tension, if you will, between the Federal Arbitration Act and the National Labor Relations Act. And the majority said, well, Congress, if it wants to ban arbitration, knows how to do that. Literally, that's what the quote said. And Congress will explicitly say no arbitration. For example, they said Dodd-Frank says no arbitration of SOX whistleblower disputes. And in the opinion, Justice Gorsuch goes through a long list of cases dealing with Federal Arbitration Act and an apparently conflicting federal statute, and said, look, we've said several times, if Congress means to ban arbitration, it will say so explicitly, quoting Gilmer, McMahon, Rodriguez, a lot of our favorites. The third prong is often overlooked, but I think it's important. It dealt with deference to the federal agency, and most of us know about the Chevron holding, which basically gives deference to an agency's interpretation of the statute it is interpreting or applying. And the court said, right, interpreting or applying. So the National Labor Relations Board is charged with applying and interpreting the National Labor Relations Act, not the Federal Arbitration Act. You've gone outside your jurisdiction, if you will. And so the court said, we're not giving deference to your interpretation of the Federal Arbitration Act. So in a nutshell, that's what the case was about, and that was the holding.
Okay, let's talk more about where the class action waivers came from. Before Epic, there was Concepcion, another case that held that class action waivers in the consumer context were permitted under the Federal Arbitration Act. After that, Charles Schwab, as you remember, started using waivers in its customer account arbitration agreements. And FINRA went after Schwab. George, please provide some background on the Schwab case and then relate that, if you would, to employment arbitrations.
Sure, and again, I can be brief. You've teed it up nicely. I mean, basically, Concepcion comes down in 2011 and says class action waivers in consumer contracts are permitted. Schwab said, oh, well, okay, and they go ahead and start putting these in their customer agreements. As Rick said, FINRA took objection to that and said, look, we got 2 rules we think you're violating. 12.204, among other things, says the consumer, a customer can participate in an arbitration if they so choose. They don't have to do the class action. They can't do both, but the customer has an absolute right to go to arbitration and or participate in the class action. So this waiver rule is a problem, and it's compounded by Rule 2268, which has all kinds of language about customer agreements and what can be in the arbitration clause. And FINRA said, you know, there's a provision in 2268 that says you can't limit the rights the customers have under the rules. So they went after Schwab. The hearing panel agreed there was a rule violation. They said, you know, the rule 12204 is quite clear, as is 2268. But they went with Schwab and said, yeah, but it's preempted. You know, the Concepcion decision preempts FINRA from legislating against class action waivers. Long story short, the board called the case, which it can do, and reviewed the case and affirmed on the violations. They said clear violation of the rules, but by Concepcion and the Federal Arbitration Act. So kind of in a nutshell, you know, where the panel, hearing panel held several rules have been violated, the board was with that, but they disagreed on preemption and said the rules on class actions, 12204, are preempted. So that was the holding, and whether it carries over to whether Schwab carries over to employment, I will answer in a nutshell. No, I don't believe it does.
Why is that?
Follow-up question. Okay, well, there is a 13204 in the industry rules that clearly governs the rights APs have to, you know, participate in a class action if they so choose. But there is no 2268 analog. There's no 2268 type rule on the industry side that says what you can and can't do regarding employment arbitration agreements. So I've no doubt that FINRA, I believe, will be troubled by a firm starting to put class action waivers in employment agreements. I think they have a problem. The first thing a firm opposing this would say is, well, okay, let's go look at Schwab. The board in the decision said, by the way, this doesn't apply to employment because there's no 2268 analog, number one. And we're going to hear about Reg Notice 1625. Says the same thing. There's no analog on the industry side regarding employment arbitration agreements. So my bottom line at this stage, in the absence of a 2268 type rule on the industry side, coupled with the board's language and FINRA's own language in 1625, I think the analogy fails, and it does not carry over as the rule currently exists on paper.
So what would you do about the current situation then, since it seems to be in a very uncertain state?
Well, as you know, I wrote a feature article in SAC on this, and at the end of the day, I tried not to be a foreman director, but I did have some advice for FINRA on this, kind of going backwards. Yeah, I think in the long run, in my opinion, they should give employees a choice. You know, just have the analogy complete, and whereas class action waivers, you know, are banned on the customer side, I think they should be banned on the employee side. That's in the long term. In the short term, I don't think they can do that without promulgating a 2268 type rule. So in the short term, in the intermediate term, they need to do that. In my opinion, in the short term, I think FINRA should get a notice out very quickly stating its views on this issue, as in, look, you know, we know about Epic systems, we know all about it. Here's what we think and what we're going to be working on. We're going to be taking a look at this. And I would think, as was done in 1999, almost 20 years ago, regarding expungements, they might declare a moratorium and say, look, until we figure out where we're going on this, firms should not be putting class action waivers in employment arbitration agreements. I think Reg Notice 1625 gives them the authority to do that, and that's what I would do in the very short run.
Thanks, George. Jeff, I want to call on you next. A lot of the larger houses, it seems, have already adopted class action waivers, and perhaps as a a tangent or an offset to that, they've also looked to other forums to arbitrate their disputes, such as JAMS and the AAA. Now, you've had, as I understand it, experience in those cases, and I'd like to hear from you about the difference among the forums compared to FINRA, if you would, and also give us a little bit on Reg Notice 1625.
Right. Well, I think Rick, that the first area to consider is this 1625, because until it came out, there had been a significant amount of both litigation in the courts and consternation among lawyers for employees that some of the firms had made it impossible to go to FINRA by entering into pre-dispute arbitration agreements. One noted one of which, of course, was the one that had a mediation requirement and then arbitration at JAMS. And when this came down, it pretty much set forth 2 points. One, that the rules could not be interpreted to allow a member, associated person, to waive his right to the FINRA forum, and 2, that if a firm tried to do that, it would be considered a violation of the old standby Rule 2010 on the standards of commercial honor and principles of trade. So FINRA now requires that there is an agreement or a sentence in any pre-dispute arbitration agreement, which might deflect you off into AAA or JAMS or some other forum, that the agreement itself does not prohibit or restrict you from filing an arbitration claim in the FINRA arbitration forum as specified in FINRA rules. So taking from that to the issue of class actions, yes, the class actions are allowed at the AAA. They have a whole supplementary set of rules on class actions, and it's been our experience that although we've had a lot of cases that I think we would describe as collective kinds of and group actions, the idea of bringing a class action in any one of the arbitration forums has numerous problems associated with it. I think just in the concept of how is it going to be managed, and is the forum capable of devoting the kinds of resources that would necessarily be needed to have a class action. So
right.
What we have done, what we've done is
individual actions at these AAA and JAMS. I'd like to hear from you about how they compare to FINRA. Do you see the forums as different in any way?
Oh, clearly. I think that you can probably sum up these forums in 1 or 2 sentences each. So I think JAMS is it's a great place, but it's very, very judge heavy, and the actions are very, very formalistic in the sense of rules of evidence, motions for summary judgment, motions to dismiss even, and some amount of deposition discovery. The AAA has some discovery, and it also has dispositive motions long before the hearing. And both of those four are lacking in, at least in my opinion, one of the things that's crucial to FINRA success in handling these cases, which is there is no adherence to either the rules of FINRA, which obviously have to be vetted and go through SEC approval, right. Nor is there any requirement that the arbitrators have any type, any of the arbitrators have any type actual expertise in the securities industry. So, as with the advent of so many public arbitrators in these various cases, that's less of an advantage at FINRA than it used to be, but it's still in virtually every case that you've got at least somebody who's got some experience in the industry and might understand the difference between a commission and a sales credit, for example. So I think FINRA is a far superior in that regard. It's also far superior with the limitations that are placed on discovery and the like to not have dispositive.
Thanks, Jeff. Since you're picking up, I'm going to move over to George. George, I wanted to go back to the Supreme Court just for a moment, if we could. You have a new Supreme Court justice coming on. It may be Brett Kavanaugh, who's in front of the Senate right now for approval. What difference is that going to make, in your opinion, if it is a new Justice Kavanaugh?
Well, briefly, I think he's going to be Gorsuch 2.0. But, you know, Zach had a couple of excellent blog posts analyzing his decisions. For the most part, they're pro-arbitration. He actually confirmed an NASD award dealing with arbitrators excluding evidence. So I think we'll see more 5-4 votes, some more than that. I mean, they're not always 5-4, but I think he'll be a reliable pro-arbitration vote, whereas Kennedy was not always reliable. So I think that's where the difference will lie. And I think also he'll be for, you know, limited review of arbitration awards. And one of the opinions I read indicates that he's going to be a little bit tight on deference. And not enough to say about that, not enough time now, but certainly look at the print article in SAC. So I think SEC and FINRA will be put to their test and should not assume automatic deference from him.
Okay. Thanks, Pat, for that discussion on the EPIC systems and the general layout and landscape of the employment arbitrations. I'd like to shift to another topic. Several years ago, key broker-dealers entered into a protocol to address rating. And that protocol has lasted and been tested and had durability in the last 15 or so years. But lots changed over the last couple of years. And Jim, I wanted you to talk about whether or not you think the protocol is expiring or evolving. And you might describe the protocol a little bit for us, too.
Sure. The protocol, what we refer to the protocol is called the Protocol for Broker Recruiting formally. And it sets forth rules for member firms and financial advisors who are moving between firms to follow connection with transitions, and provides that if you follow the rules, then there's going to be no litigation. As you said, Rick, it was adopted a number of years ago, maybe 10, 12, something like that.
And has it worked?
Say it again?
And has it worked?
I think it has worked by and large. Both Dana and I were involved in this type of litigation in the bad old days, and it used to be that there were, TRO actions, filed basically every week. 1 week the firm would be in court as a plaintiff acting outraged, and the next week the same firm would be on the exact opposite side of the issue, and it was getting a little silly, honestly. So they put together this protocol, and I do think it has really, really reduced the number of these cases that go to court. All right, but that sets the stage for the recent development that I think we want to discuss here, which is that at the end of last year, Morgan Stanley in November and then UBS in December dropped out of the protocol. Two of the founding member firms, and there was some concern that would lead to the quick unraveling end of the protocol. But there really hasn't been the rush for the exits that people were predicting. The big firms, by and large, have stayed in the protocol. And in fact, since Morgan Stanley and UBS withdrew, more than 100 new firms have joined. The new joiners have been RIAs, or small independent firms, by and large, and that's been the trend for several years, and indeed was one of the reasons that Morgan Stanley cited for dropping out, that they were sick of losing brokers to these small firms that joined the protocol, and is only a one-way street to those small firms without any reciprocity of brokers being hired from those firms by Morgan Stanley.
I see. Yeah, go ahead.
I was going to say, one people have asked me, well, what about movement? Is there still a lot of movement going on between firms? I'm not a recruiter, obviously, but my sense that hiring has slowed. Much of the movement, as I said, I think has been to these RIA or independent firms. It certainly does seem to be sort of the flavor of the month in the industry. But the pendulum usually swings back in things like this. And I think we may eventually see a movement back to the wirehouse firms, especially if they start offering the kind of money that they once were. I hate to be cynical about the matter, but no matter how much some of these guys claim it is about freedom or getting out of the wirehouse environment so they can make the right decision for clients, for some of them it is really about the money, and they will soon enough be looking to replenish their bank accounts and be willing to take a deal with one of the big firms.
Sure. Well, that makes sense. Dana, Jeff, do you have anything you want to add to the discussion?
Well, this is Dana. I'll say that there's been a lot of discussion about could there be a protocol version 2.0 that maybe Morgan Stanley, UBS would be willing to sign on to, and I don't think that's probably going to be viable. I think some of the biggest objections that the big firms like Morgan Stanley and UBS had was being victimized, as Jim said, by the RIAs, but also the fact that even among the bigger firms, there wasn't an all-in for the enterprise concept. In other words, you could have a bank with a broker affiliate, and the broker affiliate could opt in to the broker protocol, but then specifically carve out certain divisions or the bank affiliated registered reps. And that was a real problem because you'd have these people going back and forth between the bank side and the brokerage side, and some would say, well, it's, we're not a member of the protocol, and they say, but your affiliate is, and they say, so what? So I think part of the problem was that a lot of these companies are upset because, or a lot of people are upset because these bigger firms who had affiliate and non-affiliate and non-bank affiliate and BD affiliate, they'd be carving people out, which didn't seem right to them. The other one was there was no mandatory minimum sign-on period. So you get these guys leaving for an RIA. Just before he leaves, he creates his RIA as an entity and opts into the protocol. Then he complies with the protocol when he leaves the big firm, and then a month later, after he's complied with the protocol, he drops out of the protocol. And I think a lot of people objected to that concept. And I think until you get people on board and get unanimity with respect to at least those two items, you're not going to see a protocol version 2.0. And I agree with Jim. The withdrawals from the protocol have been very few, and it's like, what is it, Jim? Something like 1,700 members in it. It's huge.
Yeah, that's right. Yeah.
I mean, it's a huge number. So that to me, I don't think you're going to see that. Whether or not Morgan Stanley, UBS ever get back in, I don't really think matters that much. I think it'll be more interesting to see is when cases actually start coming out, and you get a Morgan Stanley or UBS broker who goes somewhere else, which is in the protocol. If he follows the protocol standards, meaning only taking the 5 fields of information the protocol would permit, how are the arbitrators going to feel about that? I think that'll be a very interesting thing when it starts to happen.
So Dana, in your observation, since this change in the protocol with the firms leaving, has it changed the landscape in rating disputes, particularly at the beginning with the injunctive actions?
No, I don't think so. Rick, I think that the protocol by its own term specifically excludes rating cases. So those cases really never were covered. Multiple broker defections where significant injury to a business unit was being alleged. I think there's probably a diminution in the injunctive practice, but I think in terms of the cases carrying forward, I just checked FINRA's website, the statistics page. I think at the end of June, 18 rating cases have been filed, which suggests 35 or 40 cases for the year, which would be on par with previous years. I'm not saying that the protocol hasn't had some effect on rating cases. I mean, I did that study a couple of years ago where I looked at win rates before the protocol came in and win rates after. And before the protocol came in, firms claiming rating won 2/3 of their cases. After the protocol came in, they only won half their cases, which could be that maybe arbitration panels were more accepting of the standards that the protocol permits, or the fact that the protocol exists would sort of suggest an industry standard or something. But they still exist, and awards are still being given, and I don't think there's any change about that. And I still get a lot of calls about that. Jim, you'll remember that 2003 conference that we did in Philadelphia, where we issued that report, a search for consensus. So there's still, requests for that out there as well.
Yep.
So yeah, Rick, I don't think much has changed on the rating in the rating context. I think it's maybe a little harder to win a marginal rating case where you don't have really good facts. But other than that, I don't think too much.
And Dana, is there anything to report from the most recent Fisher & Phillips broker recruitment seminar?
Well, as you know, we sign confidentiality agreements when we go to that, Rick. So I'm pretty tied in there. But I will say this. I think there's a sort of a general consensus among those who attend these conferences that the protocol is injured because of the departure of a couple of big firms. Some say it's on life support. Others say, no, it'll continue, but in a sort of like slightly degraded state. I think a lot will depend on whether the other big firms decide to opt out as the next year or so moves on. If you lose the big firms, and which represent a disproportionate number of brokers, then I think you probably may see the end of it. I don't think that regional firms or RIAs have any interest in going into the protocol to protect themselves against each other. They go into the protocol to protect themselves against the wirehouses.
Anybody else? Further remarks on that, or can we finalize this discussion? Well, thanks, and thanks to you all for an excellent program. I want now, before we wrap up, though, to ask each of you, if you want to join in, to make your predictions for the future about the topics that we've discussed. So, George, if you'd lead off, I'd like you to talk about FINRA and where it's going to land on class action.
I think they're going to do what I suggest, and class action waivers will be banned on the employment side. The wild card is whether one of the firms challenges the preemption argument, because Schwab accepted the board's decision, but I think 3 years from now they're going to do what I say.
Okay. Jeff, you choose your topic, financial industry employment cases, FINRA or AAA? Who will have the most?
I think that there's no question that FINRA will have the most. The real question is how many will there be 3 years from now? Because I see a general decline in the number of cases, and there are a lot of factors for that. Certainly on the institutional side, it relates to so much deferred comp being used to matters before they get to litigation. And on the retail business is obviously changing greatly, and the issues there are much less frequent, I think, for compensation-related issues. So I think FINRA for sure. And I would also say that one of the reasons would be that as long as the claimant in this case is the employee, it's highly unlikely that or claimants are going to recommend.
I'm going to go to Jim, Dana, for final remarks. You've already talked to us about whether or not you think the protocol will still exist. Is there anything else you want to prognosticate about?
Jim, this is Dana. I think one thing is clear, and that's expungements are going to get tougher. There's probably going to be more careful selection by the broker's attorneys as to what cases they think they can get it in. I think they already do a pretty good job of that. But I sort of bemoan the loss of the explained decisions that you get in there, because it's about the only time that you get a window inside the thinking of arbitrators and what's important to them. And you can, if you really took the time and read all of the expungement awards and understood why arbitrators grant expungements, is it really about the broker, or is it about the claimant? It's sort of an interesting exercise. If you had unlimited time, you could read them all. But.
Jim?
Sure. For my crystal ball prediction, I guess I'm going to have to I think I disagree a little bit with Dana about the future of the protocol.
Oh,
Although
good.
the protocol, although the protocol did not evaporate, I do see continued pressure on the protocol and changes ahead. And the pressure isn't from competitive concerns, but from regulatory exposure on the privacy issues that are inherent in the taking of information that the protocol allows. Raymond James got fined a few years ago with respect to privacy issues in its hiring practices under the protocol. And it was very recently reported in the industry press that Wells Fargo sent out an amended privacy notice to clients, giving them the option of opting out of information sharing under the protocol if their broker left. And then also that Wells Fargo has created a database available to its brokerage force showing which clients have opted out. And personally, I can't imagine that Wells did that, took those steps of its own accord. Have to assume that FINRA was involved behind the scenes in some fashion, and that we may eventually see some sort of AWC announced. So I think that such regulatory pressures will continue to impact the protocol, and that there will be possibly some sort of protocol 2.0, or maybe even two competing protocols, one for the smaller firms and whoever else wants to be part of it, and one for other firms.
Yeah, and part of that may be because of regulatory pressures, not the recruiting dynamics.
Exactly.
Great. Well, very interesting discussion. I want to thank the panel for an excellent program. Dana, George, Jeff, Jim, great job. And thank you to audience for listening. Goodbye now.